would like to welcome you all to this panel that we organized from the Blockchain and Society Policy Research Lab at the Institute for Information Law at the University of Amsterdam on the intersection of blockchain or distributed ledger technologies and the GDPR. Last year, in the same room, there was a panel on blockchain technologies, and the room was overflowing. Today, I see the interest has waned a little bit, but that's good because we can actually talk about serious stuff. My name is Balazs Bodo. I'm the founding director of the lab, and we organized this panel to actually explore whether we can expect similar developments in the distributed data technologies and the GDPR domain that we witnessed in copyright and file sharing technologies, where around the same time, two very different approaches to how content, or in this case data, can or should be organized, one technological and the other is legal, and they very quickly locked themselves into a mutually reinforcing vicious back and forth, a WHAC-A-MOLE, where file sharing technology started to react to the ever increasing sophistication of copyright legislation, which in turn prompted more decentralization, which in turn prompted legal sophistication, which in turn prompted more decentralization, and ultimately where we got to was a super sophisticated legal regime with very little effectiveness when it came to curbing illegal practices. The question for this panel today is whether we can expect anything similar within the data protection and privacy domain, where decentralized databases is one technological mode of data regulation, and GDPR is a legal one. Within the panel, the moderator will be Mireille Hildebrandt. She doesn't need introduction, probably for this crowd. We are very glad that, Mireille, you could accept this, this task, and we're very glad to have you here. And in the order of speaking, we're going to have a number of excellent experts on this field. George Danezis is a professor of security and privacy engineering at the University of College of London. Konstantinos Stylianou is a competition law and regulation expert at the University of Leeds. David Liberti is a legal and policy officer at DG Just at the Fundamental Rights and Rule of Law Directorate. Alexandra Giannopoulou works with us at the lab. She's a researcher in data protection law. And our last speaker will be Miche Finck, who is the Senior Research Fellow at the Max Planck Institute for Innovation and Competition, and also a lecturer in EU law at the University of Oxford. So without much further ado, I ask you, Mireille, to be the ruthless enforcer of rules for this panel.
Is he saying ruthless, not rootless? Huh? Yes, so this is not a decentralized blockchain. That means that there is going to be moderation. We're going to have 5-7 minutes talk. After each talk, I will quickly launch a question with a quick response. After that, we'll have an intra-panel discussion, because I think there are very interesting differences of insight in the panel, and then we hope to have 10 minutes for Q&A, because I'm absolutely sure that you will come up with very fascinating questions. So I give the floor immediately to George.
Thank you, Mireille. So this panel is about blockchains and the GDPR. Throughout the Q&A and later, we will discuss a lot of kind of point problems, from rights to be forgotten to copyright, etc. But to introduce this topic, I would like to zoom out a little bit and highlight what I think the fundamental tension is between the blockchain technology, distributed ledger technology, and the data protection regulations broadly, as we've had them for a while. Now, the GDPR is a regulation within the broader tradition of data protection. And I mean, these kind of regulations have served us for a very long time, but they also have historic roots that somehow they carry into today. Now, the GDPR tries to be technology neutral. And to some extent, the longevity, at least, of the data protection principles show that it has succeeded. Those kind of regulations have succeeded to some extent to adapt to changing technologies. However, they do not entirely succeed to rid themselves from one important question, the fact that they presuppose, I would dare to suggest, a particular architecture of data processing. In particular, data protection regulations presuppose that there exists an abstract entity, one or more companies, individuals, whatever, that act as data controllers, and that entity, the data controller, abstractly may use some other entities to delegate some processing, the data processors, under the authority of the controller, and that this whole operation is geared towards processing, of course, personal information that can be ascribed to particular data subjects that have, of course, some rights and some expectations vis-a-vis the whole data processing, which is highlighted by the data protection principles. So this sounds very general to some extent, right? And indeed, that general architecture, that general shape of relationships between those entities indeed maps to places where serious violations maybe of individual freedoms or serious concerns that would prevent people from accessing services have occurred in the past, in government databases where the government or a particular department is a controller, or in the last 20 years in online services where you have large internet companies acting as controllers, etc. So to some extent there is some legitimacy in presupposing this architecture because it really speaks to some serious concerns people have about the processing of their personal information. However, this particular shape of relationships between those entities, sadly, maps quite poorly unless you really try to twist the way you see things, and some legal scholars are trying to do that, of course, to blockchains and to generally decentralized systems, if you want to broaden a little bit the topic. In decentralized systems, the objective is to avoid having central parties, a single or even a collection to some extent, that do have the control over the processing that the GDPR and other data protection regulations kind of presuppose. The processors in that case act on instructions that are fixed and to some extent cannot easily be changed. And the data subjects very often provide much more detailed transaction data because they effectively try to participate in a common to create the emergency of trust around a currency or something like that that is not backed by a central authority. So I dare to suggest that a lot of the problems we will discuss today may have as their foundation, may have as their starting point this fundamental tension between a presupposition of centralization of control within data protection regulations and the presupposition of lack of centralization of control in decentralized systems. Now, of course, this is very abstract, and particular systems embody those values in different ways. And we will discuss all that, I hope, throughout the panel. But I will start with this provocation and allow the next speakers to go on and come back to that in the questions.
Okay, quick question. I would challenge the idea that basically you're talking about public non-permissioned blockchain. So what if, playing the devil's advocate, I say they're not decentralized at all? There is a very clear power structure, maybe not a formalized authority, but there's a power structure there that informs who's writing the protocols, who's mending the protocols, what are these miners doing that are not so distributed as many people think, because many of them are in China, right? And taking a little bit further towards smart contracts, for instance, who is writing the code of these smart contracts? Because usually the parties that will enter those contracts, unless they are tech-savvy, have no idea what they're getting themselves into. So wouldn't it be a task of the law to figure out that power structure and then to attribute the status of controller to the right entities, and that this is what we're struggling with, and that this is what we need to do, because we don't want a hidden power structure that is then proclaiming itself to be decentralized.
Yeah, I agree that to some extent, in order to have a mature conversation, one has to look at the details that you have outlined, and the whole devil is in the details in this particular space. So just to take one example, because I think it's actually quite an interesting example in the context of data protection. Indeed, in a smart contracts platform, the contract writer effectively determines the logic of the processing. And therefore, you can say, well, isn't that really the controller? Because they effectively tell the system how to operate the system. However, on the other side, again, once the contract is written, it's fixed and immutable. So it is not afforded, let's say, the ability, if there is a judgment that says, oh, and by the way, we interpret data protection regulations as meaning something different than what was in the logic of the processing, to adapt to that very easily. So even though there is some locus of control within different entities, the whole architecture is set up for that control to go up to a point and then be to some extent relinquished. And all of that is a matter of degrees, and it depends on the platforms, etc. So it is not, I think, the case that we will be able to do some kind of deep investigation and be, aha, I found my controller, and this is the same controller as the state was for a state database or a service provider was for something else. We will have to be more sophisticated in our investigation in order to do that and understand where the power lies for different things at different times.
Yeah, I think that's absolutely right. For me, the question, but we'll move on to the next speaker, is if you initiate a smart contract and it's to some extent immutable, so you cannot comply with a court order, whose problem should that be? The court's problem? No, I would say what I would call the controller, but okay. The next speaker is Konstantinos.
Konstantinos, yes.
Oh yes, Konstantinos.
Thank you, Mireille. And thank you, George. I think my main argument follows up and builds on what George already said nicely, in that I think we can all agree that blockchain is a set of technologies that is fundamentally incompatible with main principles of what we now understand as privacy and data protection law. And one of the points that George made was that perhaps the main reason for that is that we're missing this element of central control, which serves as the point onto which law would ascribe certain obligations on how to make sure that privacy and data protection is assured. So if we're missing that central point of control, how do we make sure that the system preserves privacy and data protection rights? But it's not just that, it's also the fact that blockchain by design is immutable with few exceptions, whereas data protection laws currently allow users to have control over their data in a forward-looking way, meaning that they should be able to have them deleted or changed after they give them up to an operator. There's the principle of limited purpose, processing for limited purposes, but if you don't really have a central authority to specify what are those purposes at the outset, it might be hard later on to stick to allowed, so to speak, uses of personal data if the user has not given explicit consent just for those, because we don't know ex ante what the uses are. So there are several points of tension between blockchain and our current privacy and data protection laws. So I guess this is sort of like indisputable, but what I'm more concerned about is what to do from that point on, and I think like most of the people, what they're trying to do is to try to fit blockchain under existing laws and regulations and see how we can make it compatible with GDPR, especially in the European Union, where we seem to think more highly of privacy and data protection. And in a way, the way I'm approaching this is that one of the options that we should keep open is that blockchain will never become fully compatible with GDPR or with existing privacy or data protection laws, regardless of what name we give them. And perhaps we shouldn't even try to make it compatible. And that may sound a little controversial because most people would say regulation should be designed to be technology neutral in the sense that we're deciding as a society, as law and policy makers, we're deciding what we want to do with rights and obligations, and then we have an expectation that we will tame technology to fit our needs, including our legal needs. So we shouldn't allow technology to tell us what our rights or obligations should be. It's the other way around. But I can give you at least 2 examples of situations where we have allowed, on the one hand, and secondly, we have creatively adapted, on the other hand, to this kind of tension that sometimes technology creates in terms of existing laws. And one comes from intellectual property and the other one comes from contract law. An intellectual property which I feel most of you would be more familiar with is the classic example of what happened with the internet and peer-to-peer sharing and copying online and all of that, which pretty much all of us do on a daily basis. And as you probably know, copyright law doesn't really care about whether our uses are commercial or not. It gives the creator certain rights, and then for others to use the work of a creator, they need to get a license to copy, adapt, transform, broadcast, and so on. And yet, this system presupposes, of course, that it's kind of difficult, we can't control, and it's kind of difficult to create copies, and also it's relatively easy to prosecute the offenders. Otherwise, the law would neither be well adapted to what we wanted to do, neither to enforcing the rights and obligations that it ascribes. And both of these break down on the internet because it becomes extremely easy to copy, share, and so on, and it becomes extremely difficult to prosecute the offenders. So we can see there that copyright law has not fundamentally changed, well, at least for 40 years, around the 70s, were the latest major changes, and it hasn't really changed very much since, and its basic principles at the very least. And yet we continue to engage in this kind of rampant copying and sharing and all of that. But we have come up with creative solutions like new copyright licenses, like Creative Commons and so on, or YouTube license, and all of these new licenses for creators and all these new ways for artists to create and then give out their work and starve. And we kind of like sort of have gotten used to this situation. We all violate the law on a daily basis, but A, we ignore it, or the law ignores us, put better, or B, we have come up with alternative solutions. But the fundamental tension is still there. The law hasn't changed, our practices haven't changed, and on a daily basis we still violate the law. And we can see the same thing with contracts. Every time you go on a website, you're bound by their terms and conditions, and yet nobody really thinks about it. Unless, of course, something goes wrong. And contract law, what it tells us is that to have an agreement, we need to have an offer and we need to have acceptance. And the offer is a proposal for someone to accept, and the acceptance is a consideration of the proposal and an expression of a will to be bound by that proposal. And so when we go on a website, there's this implicit assumption that there is an agreement between the viewer, the visitor, and the website operator. But the thing is that this breaks down over the internet as well, because we don't really have an offer, because nobody tells us that we are bound by certain terms, and we don't see those terms, and we never agree to those terms. We never read them, but we never take any action to agree to them. And so under contract law, at least, strictly speaking, there is no agreement. And I was just very recently reading a case in...
We're now at -1 minute.
-1 minute. I'm wrapping up in plus 30 seconds. There was a case in the United States where a number of people went after Uber, alleging certain privacy, certain violations, one of which was the mandatory arbitration clause in Uber's terms and conditions. And the First Circuit in the US agreed that this term is not binding because A, users were never made aware in a conspicuous manner that there is an offer to be bound by those terms, and they never had an opportunity to actually click on anything or express their will. And yet we see that again on an everyday basis, that that's how the internet works. We seem to be bound by agreements, but they're not agreements under strict contract law the way that we're used to. And so I see the same sort of like tension with blockchain. It's a new technology that basically doesn't fit in very well with the law as we know it. And it seems to me that what's going to happen is that neither the law is going to change, nor the technology, and we're going to continue to have this sort of like tension, and we should keep that option open as a potential and viable future situation.
Okay.
For abusing my...
Yes, wonderful. You abused it wonderfully. If somebody tells me that the law and a specific technological, socio-technical system, like in this case, blockchain distributed ledger technologies, is basically incompatible, and then goes on to state that this is indisputable, that I immediately feel an urge as a moderator to start disputing this. Then I get examples from both copyright law and contract law. Would be very detailed comments on that also because United States contract law and the kind of legal remedies people have differs, of course, from that in Europe, especially the directive that regulates remote sales basically enables you to send everything back within 2 weeks, and you don't even have to explain why. The tables seem to have been turned there. There's the fashion industry that gets their clothes returned in 50% of their sales. So is this indisputable? Is that the right starting point? Or should we say, well, when you look at copyright law, you see all sorts of negotiations, because that's what you're basically saying, different interpretations. Also, copyright law is trying to protect de facto big firms, not just the poor author, while, for instance, data protection law is trying to protect data subjects. So the protection seems to work differently, and that might also impact the sort of solutions. So just a very brief question. I want to push you on the indisputability. What does that mean? Are you saying this is how it's going to be, or are you saying, well, maybe data protection law is a different animal, and depending on how the courts work with this, it may be possible to say if you put a smart contract on the chain, you will have to make yourself sufficiently identifiable such that a consumer can act on you if they did not get their stuff. Do you think that is indisputably impossible?
Right. So the short answer is that, in a way, I may have overstated the case that there is a. I didn't want to imply that there's a full and complete tension between blockchain and privacy laws, but there is certainly certain areas that the technology has been designed not to violate GDPR, but regardless, independently of GDPR. And I guess that there will be some aspects of blockchain that will never be reconcilable with privacy and data protection laws. But I didn't want to imply that all of the aspects of data protection law will become inapplicable, or all of the aspects of blockchain will show a fundamental disrespect to data protection and privacy. But it is indeed a matter of degree, and even in the examples that I mentioned, copyright and contracts, there are obviously a lot of cases and a lot of transactions, and a big deal of what's going on is compatible, but there is also a very significant degree in which it isn't. And so a law that is being violated on a daily basis by millions and millions of people, whether that means going on a website and being or not being bound by, their terms of use, or repeatedly violating copyright law on a daily basis by sharing images that are not necessarily covered by fair use and so on, we do see that this is extremely common. And so a law that is violated on a daily basis to such a large degree, I think there is something to be said there about how blockchain relates to current law and what we can do about it based on examples of previous cases where we've seen such rampant disregard for what is happening between a technology and a law. And I'm assuming that either the law will fundamentally change or the technology will fundamentally change, or none of the two, and we will continue indeed to see this everyday fundamental tension, which I guess is fine.
Thank you. I'm going to move on immediately to David, and I'm very curious how he's going to respond to this, because it's quite a challenge if somebody says that this can never be GDPR proof.
Okay, thank you very much, Mireille, and thank you to the organizers for putting such an interesting and relevant topic on the table. Indeed, my intention is to provide a general overview of the DG Just's position on this issue. I intend to build my short intervention into 3 parts, mainly with a short introduction, then going on to highlight the points mentioned already now by some of my colleagues, and finally to conclude and giving you an overview of what is being baked currently from an institutional and regulatory perspective. So first, to begin with, as already I have been introduced, I am from Unit C3 of the DG Just Commission. So we are the unit which has negotiated the GDPR. So I am not a technologist, I am just a simple lawyer who works with the laws found in the GDPR. I also happen to be a proud father of 2 daughters, aged 5 and 3. And we play this WHAC-A-MOLE game quite often. So the first thing which clicked is, why are we putting such a question on such a debate? Is this the beginning of a beautiful privacy WHAC-A-MOLE? Of course, I will spare you the details of how this poor mole gets spanked by my daughters, but it tells us something. Do we really want to envisage a world where there's a regulator spanking, hitting, whacking this poor mole, this poor technology? And who's the mole and who's the technology? So this is a very interesting and very provocative question. However, the reply is quite simple. We have a law, the GDPR. It took more than 4 years to negotiate and entered into application last May 2018. There is no discussion on the table currently for any revision or any amendment. So that is the first important thing to keep in mind. Of course, I have before me people who know quite well the GDPR, so I will not go into the definition of personal data. What is personal data? What is processing? You all know that the GDPR, which is crystallizing the case law, offers a very wide interpretation of personal data and processing. We also heard before about this technology neutral, so it will apply the moment personal data is being processed, irrespective of the technology. So these are basic premises which have to be kept in mind. We also know in this area, now moving a bit more specifically, that, for example, Article 29 in 2014 issued its guidelines on anonymization. And we also know, and we can safely conclude, that the level is quite high, the bar is quite high to actually conclude that data is anonymized. We will also, I think, touch on these issues throughout the forthcoming 45 minutes. But when we look at the GDPR, one of the first glaring important issues in this context, and has already been referred to, is controllership. I know that Miche will go into this further on. So it is, whether this is a decentralized or a centralized system, the moment you have processing of personal data, the GDPR applies. Then we will discuss also the principles and the rights of data subjects. Some of the data subject rights are easier to comply with, some might be harder because of the nature of the blockchain. These are also found in the GDPR. It's a law which is currently in application. Then also, if we continue in this importance of highlighting factors within the GDPR, there's also the question of international transfers. Where is this personal data going? Beyond the EU, within the EU? So these are all issues which we will touch on throughout the forthcoming 45 minutes. But also within the GDPR, we find some solutions. When we speak about data protection by design, data protection by default, these are principles which are there to make and ensure the possible compatibility. And last but not least, let's not forget that the main reason of the blockchain and one of the purposes of the GDPR is to empower data subject rights. So the principle, the starting principle, seems to point to compatibility. Clearly, the way blockchain is fashioned needs to take into consideration such points which I have mentioned, which will be mentioned. Therefore, when we start speaking about compatibility and compatibility, whatever the technology is, has to be developed in a manner which complies with what the legislators have decided. Now I jump to the last part, which is the conclusion. So what is being currently baked from a regulatory and institutional perspective? Most of you know and are familiar that sometime towards the end of last year, there has been guidance provided by the CNIL, the French Data Protection Authority. We also know that there's this ongoing importance that blockchain needs, anyone who's developing something needs to know. And without information, innovation might be stifled. So there is an ongoing process within the European Data Protection Board, and I see also here one of the chairpersons of a subgroup which will be dealing with this issue. There is currently a reflection, ongoing reflection, to discuss this topic. Therefore, also at a regulatory perspective, there is ongoing reflection to see how to deal with this topic. They are still early days, and I cannot really say much because it's still early days, but there is an ongoing reflection in this area to see and explore and have the highest regulator body. So the European Data Protection Board is indeed the group of different supervisory authorities within the EU who are now reflecting on this point. And also with regards to the Commission, you might also be familiar that there's this European Blockchain Partnership, which is which includes member states and the Commission ways of improving, making use cases which are compatible. And there is also the European Blockchain Forum. They have also in this regard issued a specific document, GDPR and blockchain. It is, of course, their views, but it includes also a lot of input from DG Just. At the end of the day, the Commission's position is that anything which is on the blockchain has to comply with EU values and laws, therefore GDPR, anti-money laundering, and it has to be as energy efficient as possible.
Okay, thank you very much. Now I would, of course, like to present you with a question. This is the position of your own DG, but maybe there are other DGs, that have a totally different position. Maybe you don't want to answer that question because you can't speak. Yes? Okay, please. Very interesting.
Okay, no,
I've heard some sounds about, well, the GDPR is nice, but we need innovation in Europe. There's China, there's the United States, so let's go for it.
No, I think it's a very relevant question. Of course, I come here as a DG Just Cap, but of course I'm a Commission official, and like everyone official, we speak amongst each other. It is, of course, quite a tricky question, but I think I can quote a very recent example. Yes, I can quote a very recent example. So, you know that Parliament has, towards October, issued an opinion, guidelines calling on the Commission to do a set of things. And the Commission, so we have the lead DG, which in this case would be DG Connect, which will then share its draft with a number of interested DGs, one of them being DG Just, and there's FISMA, there's TaxSud. So there was this inter-service thing. And when the draft came, so we had a question from a particular MEP as a follow-up. When the question came, it was quite clear, and they wrote that the ambition, so this MEP was asking, what is how will the Commission ensure that how is the Commission planning to provide environment of legal certainty that is needed to boost DLT and blockchain? So the reply comes from DG Connect, and it clearly states its ambition is to meet the most advanced cybersecurity and energy efficient standards while ensuring full compliance with EU data protection law, the GDPR. Now, normally when we get these questions, people within our unit, we have to change, redraft, do a lot of, in this case, they wrote this clearly, and we didn't even touch the reply. So this shows, I think, that it's the same philosophy within the whole Commission. Thank you.
Wow, the Commission is really taking up challenges. Alexandra.
Yes, I had some slides there. I don't know. Should I do without?
Or this, yes,
Go.
fantastic. Yeah.
Oh, yeah. Oh, great. So, yes.
Can you see the screen? Yeah.
Yeah. Hello. So I prepared some slides as well to sort of guide my reflection here. I'm going to be focusing on a specific principle of the GDPR and the rights and obligations that it implies, the data minimization principle on the blockchain. And first of all, starting talking about what sort of data that would imply. It would imply the data that are stored and processed and that circulate on the ledger, on the distributed ledger, on the database. And that includes, for example, all the transactions that happen, which address, so which person, which identified person sent what to whom. And so you have the transaction data. You have hashing data, you have encrypted data that circulate and that are qualified as personal data. And in principle, the design of the distributed ledger is such that heralds as a feature the fact that you cannot change it, and also the fact that it is an append-only database. So you have a database that keeps growing and growing with all these amounts of data that are essential to the functioning of the blockchain. So you have, on the other hand, you have the data minimization principle that requires that only data that are personal data that are adequate and necessary for the processing and for the specific purposes that they be processed. And you have the obligation to the data controllers that they enforce data protection by design and by default. And essentially, we don't know what that means for with append-only distributed ledgers. What has happened is that in between this tension, you have the current technological features that are trying to be implemented on different types of blockchains in order to ensure further privacy protection. So that comes also as a conciliation point between the GDPR and the blockchain community and blockchain technologies, because they are both privacy aware. They try to enforce and better protect the privacy of the individuals that are involved and that are transacting on the blockchain. So you have the very famous now zero-knowledge proof that is being implemented in various different blockchains. You have other types of practices as rig signatures or other specific technologies that permit to verify the accuracy of a transaction without actually revealing all the information behind it. And you have also the same basic principle that applies to smart contracts, trying to only reveal the path that actually executes at the smart contract and not all the different pathways that weren't executed, in order to better protect the personal data that are going to be revealed and processed on the blockchain. However, the problem is that these are all technologies that are still nascent, and they apply to different projects, but there is no unified solution to that. There are no standards, and there is also no opinions about which technology of the aforementioned ones would better protect them, protect the personal data. And even if we consider that that would be the case, then the governance question comes in the sense that who would take those decisions. So there are some specific blockchains, as Mireille would have mentioned about private permission blockchains that would potentially form the decision-making of which privacy-enhancing technology to use and how we process the personal data that are necessary and adequate for the purposes of the project that we build. But in bigger projects, in permission projects such as the Bitcoin blockchain, then things would get a little bit more complicated in the governance of how do we apply the privacy by default principle. Would there be any conciliation point inside? I think that it would be or logical to assume that there would be at some point, like the CNIL opinion, but a more informed opinion, a more informed assessment of the different technologies that are applied, and accept some of those technologies as respecting the data minimization principle, or we would have to wait on some specific case law that would be used at a specific use case to evaluate how personal data processing is perceived by the judges. And finally, on the technology's point of view, the fact that we assume that there would be some standards or some accepted technologies involved in order to protect their privacy, what would that imply for blockchains that choose to implement a specific privacy-enhancing technology or something different, or not at all? And what would that mean on the liability side for those projects? And that is all for me.
Okay, thank you very much. So just imagine, there's a big difference, of course, in terms of control. Control sounds very bad, but control means you have somebody that you can address as being responsible. And one of the problems with the public non-permissioned is that that is much more difficult to decide. So what if problems like storage limitation, one core principle of data minimization, are very difficult to be met by a public blockchain? What if there is a case, not even a liability case, but an injunction by people who go to court based on Article 79 of the GDPR and say, I want to file an injunction and I want this public blockchain, maybe the Bitcoin, to stop processing my personal data because clearly that's unlawful by now, it's exhausted. I would side with David here, sorry, not with David, but with Konstantinos here. Well, the court can then say, yes, I order the blockchain, but the blockchain is not a legal entity. Do you see somewhere there something like solutions possible?
So I think that, again, on this implies a certain form of control of the blockchain. So you have, even in public and permissionless blockchains, you have various levels of control. Of course, I consider the Bitcoin example that you said is the more difficult one to consider and enforce. But I think that it would be either the technology in itself, so the community in itself, that would progressively take up on those measures, as they have been progressively taking up some privacy-preserving technologies, or it would go through the emergence of various intermediaries that are already being taking up a big space in the Bitcoin blockchain world.
Okay, that's like they're going to do it, but if the court orders the blockchain to stop processing the personal data, let's combine Article 79 with Article 80, so make it a class action or collective action. That is, all member states have to implement that if it's not about damages. So then the court tells the blockchain, you have to stop processing Mireille Hildebrandt's personal data.
I think, and to reverse that question, I think that for the court to order that, they would first have to prove that they are processing, that there is some data processing happen from European citizens, or that you can maybe divide between the European nodes and the non-European nodes.
Yeah, but there will be some jurisdiction,
Yeah,
because I'm
yeah.
a European citizen, so I can say, I want you to stop processing my personal data, full stop. Basically, let's face it, that is what Konstantinos is saying, that's not possible. So I totally agree, we have some problems here. Thank you very much, and the final word is now with Michelle.
Okay, thank you very much. So I'll speak a little bit about how we might be able or might not be able to map the concept of the data controller to blockchain technology. And I should say that I've been following the discussions regarding the compatibility or incompatibility of the GDPR and blockchains for about a year and a half now, and I think that this is really one of the issues where people find it hardest to reach common ground on. And as I'll try to show in my talk, I think there's essentially two reasons why this is the case. One is to be found in the nature of the technology itself, and the other one relates to the pretty uncertain state of the law in this respect right now. So George has talked about the technology in itself and how it furthers decentralization and how we might consider that this stands in tension with the sort of like centralizing paradigm that we have inherent to the GDPR, so I'm not going to say more about that. But I think there's something else that's worth flagging. So oftentimes we're talking about how to map controllership to blockchains as if there was only one form of blockchain. However, this is something we really shouldn't be doing, to the extent that the concept of controllership under the GDPR, as we know, is both contextual and functional. So really what you need to do is have a detailed case-by-case analysis to determine how or who is a controller in relation to a specific processing operation that relies on a specific blockchain. And I think that beyond the ordinary factors that you would take into account in this respect, there's three that are worth mentioning in the specific blockchain context. So the first one is design. Are we talking about a public and permissionless blockchain? Are we talking about a blockchain that's private and or permissioned? The second one is perspective. Are we talking about the system as such, or a specific transaction that occurs in the system? And the third one is that of the ecosystem. So are we talking about controllership in relation to the infrastructure, to the very blockchain as such, or are we talking about controllership in relation to an application that might be built on this technology? And then there's the law. So when we look at how the concept of the data controller is currently being, when we look at the concept of data controller in the GDPR, there's currently a lot of uncertainty regarding both the qualification of a controller, but also regarding the consequences that flow from being qualified as a controller. So when we look at the text of the GDPR itself, we see that Article 4, Paragraph 7 tells us very clearly that the data controller is the natural or legal person that determines both the purposes and the means of data processing. And while this looks like an easy and straightforward definition, we know that it isn't so easy to apply in practice. So over the past 20 years now, I think, it's become pretty obvious that the purpose and the means aren't two criteria of equal standing, but the court has made it very clear that the purposes are actually more important to determine who's a controller than the means are. And this is something that's now being carried forward in the court's case law on joint controllership, where the court has again made clear that you actually need to have very little control over the means of personal data processing in order to qualify as a controller. So over the past year, the court has decided two cases that are important in this regard. There's a third one pending. So in Wirtschaftsakademie Schleswig-Holstein, the court said that the operator of a Facebook fan page qualifies as a controller. In the Jehovah's Witnesses case, the court stated that you can be a data controller without actually having physical control over the personal data that's being processed. And more recently, in the Fashion ID case, where there's not yet a judgment, the Advocate General Bobek held that someone who's using a plugin, such as a Facebook like button on their own website, qualifies as a data controller, even though they might have no influence whatsoever over the actual parameters of the means of data processing. So when we take this case law together, what we're seeing is that today, potentially, anyone who chooses to use a certain technology in a manner that facilitates the data processing, even if this is happening by someone else, qualify as a data controller under the GDPR. So this is an incredibly broad sort of take on the concept of controllership. And when we then go back to the specific blockchain example and we try to map the court's recent case law on joint controllership to blockchain, it becomes very obvious very soon that more likely than not, in many circumstances, there will be many joint controllers whenever personal data is being processed through blockchain technology. And on the slides, I talk a bit about the different actors in the ecosystem and how or under which consequences they might or might not qualify as controllers. In the interest of time, I don't really have time to sort of go into all of them in detail, but I think that the most interesting really, and maybe this is something that we can discuss in the discussion section, is that of the user. Because essentially, depending on how you interpret the household exemption in that respect, you might have a situation where a data subject becomes a data controller in relation to their own data. Now, stepping back a little bit, you know, at first sight, I think many people are saying, okay, it's clear there are many data controllers in relation to a specific personal data processing operation that uses blockchain, and there's many reasons why we might think that having many controllers is actually not a good thing for the data subject's protection. However, to what degree that actually is the case or will be the case significantly depends on what the consequences of a finding of joint controllership are. And again, this is something where the law isn't entirely clear. If you look at Article 26, which deals with the obligations of data controllers, you see that paragraph 1 says that the joint controllers should conclude an agreement between themselves in which they decide what their respective responsibilities and obligations towards the data subject are. However, you then have Article 26, paragraph 3, which says that irrespective of that agreement, the data subject may be able to turn against any data controller to enforce their rights. And I think here it will be crucial for the court to determine what the temporal dimension of paragraph 3 is, to the extent of knowing whether a data subject can address any data controller to enforce any of their rights at no matter what stage of the entire data processing chain, or whether it's actually limited in time and scope to the extent that the data controller would just have to comply with things that actually relate to their actual influence on the data processing stage. And this is something that both, I think, Advocate General Bott in Wirtschaftsakademie Schleswig-Holstein and Advocate General Bobek in Fashion ID suggested that it should actually be limited and that every joint controller should have a very limited responsibility over the things that they can actually influence. So I think it will be interesting to see where the court goes with that, maybe already in its judgment in the Fashion ID case. And that this is ultimately one of the key factors that determine what the consequences of being a joint controller in relation to a personal data processing operation using a blockchain.
-2 minutes.
I'm done. Thanks.
Okay, thank you very much. I think there is an enormous scope for discussion, and I want to move immediately into the discussion of the panel, but I will start throwing the question to Michelle. Actually, before starting, I have 2 questions. So one question that I'm now going to pose to you is, if we have to conclude that a non-permissioned public blockchain does not have the kind of structure where you can address somebody as being responsible, if you, for instance, have to address 2 million people, most of which are in China, would it be thinkable to say that that must be then an unlawful organization because, well, they are unaddressable? This is just a question I want to ask. Then I also want to ask a sort of 180% different question, starting with George. Could it be that actually some blockchain applications support the GDPR and could actually contribute to compliance with the GDPR? But let's first start with the other question. Would it be an idea, Michelle, to conclude that a non-permissioned public blockchain should be considered a prohibited or to be prohibited organization from the perspective of European law because it cannot be held accountable and it has an enormous impact on people's lives?
It's a difficult question. I mean, I guess it depends on the circumstances and on their willingness to comply with data subject requests if they are ever to receive data subject requests, right?
Who's they?
Well, I guess this is the really interesting point, to the extent that there's two ways of looking at that, right? I mean, if you look at the big public and permissionless blockchain, the day is both the collectivity of actors that decide, that suggest software updates, that decide on software updates, that add data to the blockchain, that process that data. So you have that day, and that's clearly not a sort of easily targetable legal actor, but the day that influences the blockchain. But I think you also shouldn't ignore, and this is something that people often lose out of sight, that even the public and permissionless blockchains that claim not to be organized, etc., they actually have legal entities that are standing behind them, right? So they are legally incorporated in jurisdictions that are usually not in the EU, but close to the EU. And even though it's not obvious whether they can't directly influence the processing of data on the blockchain, they still have some degree of influence over the actors that can. So I think the governance questions are ultimately what's really interesting here.
Okay, fantastic. Konstantinos.
Thank you for this, for allowing this intervention. But can I just take a huge step back and set blockchain into perspective? And that should be sort of like a guiding principle for those who believe in it with regard to anything that we want the law to do with blockchain, which is that this is probably the very first time in the history of human transactions that we came close to developing a technology that allows person A to transact with person B without A knowing B, without A trusting B, and without any intermediary between A and B. And it has tremendous value in allowing people to communicate and exchange data, information, finances, and so on. And we want to take this technology, this revolutionary technology, and strip it down to take away everything that we don't like about it because it's illegal based on our current thinking. And I'm just realizing that I'm a lawyer and I'm basically speaking against the law right now. But think about it. We have a huge opportunity right now, and we might want to say no to this because over the past 10 years, we just don't know what to do with that technology in terms of the law. And we're thinking about ways to strip it down from all its functionality and trying to develop ways to make it compatible with what we already know the law wants to do. And then if you do that, you're basically, congratulations, you got a plain database, which we already have as a technology. So in everything that we want the law to do with regard to blockchain, let's just keep in mind what blockchain has the ability to offer us and whether we want to subsume that under the last 50 years of privacy or any other type of law thinking, or whether we do want to give this technology an opportunity to develop in ways that we just haven't anticipated so far.
Okay.
We might actually need very, very much.
Okay, thank you very much. It's a very clear proposition, and I'm going to soon move to George because he's going to explain how that's going to happen. But I always get extremely itchy if somebody says that we're talking about a trustless technology. Why? So you're actually asking people that are not tech savvy, that's most of us, to now trust a technology that they absolutely do not understand with a backend that is uncontrollable and unaddressable. So we are not, please, talking about trustless, but about the displacement of trust. And we all know that behind both the permissioned, private, and the public non-permissioned, there are power structures that are using this technology for something. So I find it very difficult to accept that with this displacement of trust, we should be happy and we should give it room to develop further without, I was thinking of the concept of legal personhood. So you can choose if you want to start an activity that might create liability. You can either choose to develop legal personhood. That means the legal person is liable, so you can hide a bit behind that. If that's not what you want, you're going to be severally liable. So in the end, this might be the solution, that if there are 300,000 million people who are considered liable, that those within our jurisdiction are going to be liable, unless the organization figures out some way of organizing their accountability. Okay, I want to go to the positive side. George.
Yeah, so I would like to pick up the point that you make. Are there also opportunities maybe to make this technology more compliant or even to be a force for good? And I think that this is actually the great tragedy with the difficulties between blockchain technologies and the GDPR, because to some extent, the GDPR, in line with other data protection regulations, really tries to create transparency when it comes to the processing of personal data. Namely, a subject that gives some data away should know what is the logic of the processing, what could be the consequences, etc. And in that sense, actually, distributed ledger platforms are extremely helpful. And like alternative architectures where you give as a subject your data to an entity and then the processing happens in the dark, you have no idea what's going on. Even if there is some illegal processing outside the purposes that are specified, good luck sending your underfunded data protection authority trying to find out what happened. On blockchains, at least the logic of the processing is for those who can audit these things or for those who can trust those who can audit these things is self-evident and in fact is immutable. So once basically it's determined, it cannot change. Now, of course, can there be side processing and other things? These are other questions. So there is a huge opportunity there, in fact, and the first white paper by Nakamoto about this, it said, not only we're going to have a currency that is not, let's say, controlled by governments, Bitcoin, but it is going to be privacy preserving. It is going to be anonymous. So to some extent, privacy was one of the early things that people thought blockchains might actually be good for. Now, the practicalities of turning blockchains privacy friendly are also very difficult because, as Alexandra suggested, you have to use extremely advanced cryptography. And the problem with extremely advanced cryptography, like for blockchain, is that the law is a little bit tone deaf when it comes to it, right? So initially companies said, well, don't worry, my data is encrypted, therefore I don't have to worry about GDPR or data protection at the time. Authorities came and said, no, actually, encrypted data is personal data. What does that mean now to us? It means that when we put encrypted data on the blockchain, even under conditions that we believe as security engineers is perfectly safe, the law says, no, this is still personal data. You have to do something better than that, at which point, basically, there is no solution, okay? So it's not just blockchains that are, to some extent, create difficulties when it comes to GDPR and technology. It is also all the other protective technologies, and I'm very delighted to talk about this in great length. However, to address both the point of Konstantinos and yours a little bit, it seems to me you're looking for a hostage. I mean, and in order to be able to exert legal control at some point, right? And I am a materialist. I don't believe in angels, I don't believe in spirits, I don't believe in ghosts, and the blockchain is not run by ghosts, right? It has a material reality. At the end of the day, there are wires, there are computers, and there are people, and they live within a territory, right? And some of them are within the EU. So if EU states want to exert their monopoly of violence upon these people, they can do that. That's not a problem. And in fact, we have other examples where member states choose to do that. So Germany, for example, has regulations that if you run a website, you have to put your name and some kind of weird number that Germans have on the website. It makes the rest of us laugh because it's like, oh, okay, that's kind of quaint and a bit adorable, right? But they can do that, right? I mean, they can do that, and I'm sure that if you're a German citizen running a website, it has repercussions on you if you don't do that, right? So in that sense, you can exert that control on the infrastructure, potentially on the developers, if we extend the law a little bit, potentially on the users of blockchains in Europe, and it may have some benefits. Now, as security engineers, we always consider these things to be quaint, because we're like, okay, well, Europe is a big place, but the world is a much bigger place, so what is the actual effect of that from a security engineering point of view? But from an actual effect, this may be sufficient. We have already seen the right to be forgotten applied to Google within the EU. They don't present some results. Well, if you're outside, maybe those results will be presented. If you go to an archive, those results will be there, etc. But legislators and judges at the end have said this is enough. And if we interpret, if you want, compliance with the law, not from the point of view of a security engineer who thinks about adversarial, well-resourced strategic opponents, but just from the point of view of the average person that doesn't want their little sister to see something, or their mother to see something, or maybe their employer, etc., to see something, very valid things, not a strategic adversary, then maybe we can just use those tools to regulate blockchains as well. So it's not a lost battle. Okay. They're not fundamentally incompatible in that sense.
Okay. I would say that the encryption as pseudonymization is related to key management. Mm-hmm. So if the keys are managed in a way that they can never be reconnected without the data subject consent, it will be considered anonymous. I'm going to the floor because we have 8 minutes or something left. First question. Yes, please. And it would be nice if you direct the question. I think that lady was first. If you direct the question to a specific panel member.
Good morning, my name is Shraddha. I am a doctoral researcher at the Max Planck in Munich, Max Planck Center in Munich. My question is generally to the panel, but if I have to direct it to somebody, then it would probably be Michelle. If you had to make a case for blockchain being compatible with the GDPR, yes, let's say for a minute that you are arguing for compatibility. How would you make a case for that in terms of purpose limitation and for right to be forgotten? So how would you do that? Thank you.
Great. Well, Michelle.
We're going to have to need to have a talk back in Munich, I think. No, so I think it's a great question. And in relation to the right to be forgotten, many people have thought about this already, right? So the French Data Protection Authority, for instance, suggested a couple of months ago that one of the means through which you might be able to ensure compliance with the right to be forgotten under the GDPR is the destruction of the private key, which, you know, we don't know if this is something that the court will be accepting, but it's definitely one of the solutions that have been suggested. Purpose limitation is something that people have thought about less, but I think it's a really interesting question because essentially the question really becomes whether you can define purpose in a way which doesn't just relate to the transaction, but whether you might be able to argue, well, if I am using a blockchain to process certain data, then I have the purpose or I intend to process the transaction, but I might also intend to contribute to the blockchain and to its continuous existence of the blockchain because that's the very nature of the tool that I am using. So I'm intending to further that. And yes, so I don't know whether this is something that people have thought about in depth because purpose limitation have definitely gotten less attention in that regard than the right to erasure, but I'd start thinking about it from that perspective in any case.
Thank you.
Very interesting. Next question.
Hello, Tobias Morschutz from Datenschutzraum Germany. Also to Michelle. The question is, we were talking about the question, we have multiple controllers and something like that, and especially in the case where we have a service provider in between, I would like to ask the question if it is not the service provider who is the controller, and he's outsourcing the processing, the validation and storage to the general public, and therefore maybe he is responsible to ensure that the public is obeying the laws in this case.
Yeah.
Can you give an example of a scenario where that would be the case? Is that
For example, if I have a provider who uses a blockchain to store smart contracts or something like that, then I give my data to this provider, and this provider then outsources the validation and storage and so on to the general public. So from my point of view, this is more like processing. It's outsourced, not the controlling.
so? The general public means the participants in the public and permissionless blockchain. Yeah. Okay, thanks. I mean, I don't know what the correct answer to that would be in a very specific context, right? But I think the example highlights something, namely that the court's recent case law on the notion of joint control has made it pretty hard to distinguish between a joint controller and a processor, right? It's just, I assume what it is that you were getting at. So I think that ultimately it would be desirable for the court to sort of further define what it takes to be a data controller, whether there are any de minimis requirements regarding the influencing of the means to be able to better make that distinction. I think right now it's difficult, and the scenario that you provided really highlights this quite nicely.
Thank you very much. Next question.
Hi, I have a question about case concerning the Bitcoin. If we imagine a situation when someone gives me their wallet number for me to perform a transaction, for example, should I ask this person to provide me a consent under GDPR concerning his personal data? Because once I have the wallet number, I can check the history of transactions made by this person, which are personal data, obviously. What do you think?
Who are you asking this question to?
It's a hard question. Who is willing to answer?
Okay, let's throw it into the panel. Okay, Konstantinos.
Can I just suggest as a very easy way out that precisely because everything is public in the in Bitcoin in particular, then you kind of like have lost expectation of privacy or personal data. It's like writing your name on a wall essentially, and what you've done. So that's public already, and I'm not sure that that would qualify under privacy laws or something like that. But so this is sort of like an easy way out. Not sure if that would be an adequate response.
Well, certainly not a legal response, but why always listen to the lawyers? Let's go to the next question.
So, hi, I'm Robin, and my question is: do you think that how do you phrase this? That immutable forms of storage or data processing, like a blockchain or some accountancy systems. I was talking to someone, like they said it's redundant all the way down to like the earliest payment of someone's loan, someone's how do you call it, salary. And if you remove one of them, then the whole system collapses. Do you think that will become like illegal because you can't remove one part of it, and like the whole system comes down with all its backups? Those become invalid because there's one part missing. The sums don't add up. In the end, nothing matches because you remove one person.
Is this a question for Alexandra?
Well, yeah, sure. I didn't know exactly who to address it.
What do you mean removing the information from the blockchain, you mean? Removing one transaction?
Yeah.
I mean, there are, I'm not sure how they work, the new patented blockchains that permit the amendment of the blockchain, so I wouldn't be able to answer that technically for sure. But I think that the way to amend an information would not be to remove it, but to actually add the information of removal to the end of the chain, so it wouldn't break the rest of the transactions that have happened since then.
So the person would still be in there, in the back, right? Like in the bottom
Yeah.
block.
Okay, storage limitation is rather limited. I think I'm going to give the word to our chair to wrap up.
Well, I would like to thank all of you for contributing to such a fascinating discussion. I think the fun has just started, and I'm really curious where we'll be in 1 year, 2 years, 3 years' time, both legally and technologically. There are really strong claims from the Commission. We'll see how case law develops, how technology develops, how usage develops, and I hope to see you here next year. Thank you for coming.